And the matter before the court is Cumberland 24-299, Ryan Booth versus Amigos Mexican Restaurant. We are being streamed live on the web, both by audio and with video. And I would ask counsel to identify yourselves by saying, for the record, by saying your name together with the party you represent, starting with the appellant.
Hello, my name is Pete Rodway Jr. I am the attorney for the appellant Amigos Mexican Restaurant.
You?
Good afternoon. Thomas Douglas for the plaintiff, appellee Ryan Booth.
Thank you. If counsel, if you are ready to proceed, we'd be happy to hear your argument.
May it please the court. We're here today to ask the court to determine, as a matter of first impression, whether the special relationship existing between the proprietor of a bar, restaurant, or similar establishment and its patron can survive the ejection of that patron for their own misconduct. It is our position that no, where a patron has been ejected for their own misconduct and has physically left the premises, the special relationship and resulting duty to protect that patron from third-party assaults necessarily must cease to exist. How that applies to this case, we're asking that this court find that once Mr. Booth was ejected from Amigos and had physically left the premises, Amigos owed no duty to Mr. Booth to protect him from the subsequent assault by Mr. Akarachi. Where there is no duty, there can be no liability. Additionally, if this court determines that the special relationship and resulting duty to protect can extend past the ejection and beyond the bounds of the premises, it is also our position that Amigos satisfied its duty of care to Mr. Booth that night, as there was simply nothing else that could be done. As a preliminary matter, I just want to note that we're asking for a very narrow ruling today. We're not seeking to disturb the existence of the special relationship. We're simply asking for an endpoint only with regards to the duty to protect against third-party assaults and only where a specific set of circumstances has been met. In this case, that the patron has been ejected for their own misconduct and they have physically left the premises. Extending the special relationship and that duty to protect beyond those circumstances is not only nonsensical, but it has policy implications that will negatively impact the entire bar and restaurant industry in the state of Maine. First and foremost, it's unduly burdensome to impose a duty to protect from off-premises third-party assaults. Maine has not directly dealt with this issue yet. There are some other states that have dealt with this issue. We cited some case law in our brief. But what the courts were finding as they were going through these cases was that it would require proprietors to essentially police the streets as to ensure their patrons' safe passage through areas that they have no control over. They're also finding that it would impose potentially limitless liability on proprietors of establishments like this, putting them in positions, whether having to choose between whether to forcibly detain a patron and expose themselves to potential liability for false imprisonment, or allow this unruly patron to remain on the premises, exposing themselves to potential liability for any harm that patron causes to themselves or others. Proprietors just simply lack the resources, the ability, and often the authority to satisfy this kind of duty and carry out that burden. In addition, if we were to extend the special relationship and the resulting duty to protect beyond the premises and beyond...
Counsel, I see that the green light is on.
Sure is.
So let me ask you this. Is this really all about premises liability, or is this just a plain old negligence case? And I say that because in BA versus Shiretown, when we talked about the special relationship and the duty to protect, we said in instances of we quoted saying that we're talking about in instances of non-feasance rather than misfeasance. And it seems to me here that what was happened is the jury could have chosen not to believe it, but that certainly the theory here is basically your guys screwed up and that the restaurant should be liable for that, and that really doesn't have to do with on-premises, off-premises. It has to do with an actual malfeasance as opposed to simply not doing something to protect.
Correct, and I believe
Well, if that's correct, then why do we need to talk about whether it's on premises or off premises?
Because I believe that to uphold this ruling based on this special duty, the special relationship and that duty to protect off premises, it's using the
Well,
wrong
let me ask
tool.
you this then. Let's assume instead of standing by, arguably holding back people, allowing the assault to occur, essentially.
Correct.
What if the bouncers had followed Mr. Booth out, and they were the ones that hit him?
Well, in that case, it wouldn't be a third-party assault. It would be amigos actually
Okay.
assaulting the patron. But I think the distinction here is to impose liability based on these premise liability principles, as opposed to simply doing this through like vicarious liability theory of negligence, right? If we could show that, Mr. Coughlin and Mr. Scott, when they, left the bar to join in the subsequent assault, if we could show that, these guys were acting within the scope of their employment and those actions caused Mr. Booth's injuries, then yes, I believe that, we could
But
find
isn't that what
amigos.
happened here?
Potentially, but that wasn't a theory that was argued in the case. There was never any finding or, or really any discussion at all, and the jury certainly wasn't instructed on what constitutes being within the scope of your employment. And there's
It
nothing
seems to
in
me
the-
that, use this case as a case to establish a territorial boundary strict rule, that this may not be the best case because of the unique facts here. And what happened here, obviously, there was a duty when the victim was inside the restaurant.
Correct.
And what happened then is that he was escorted by agents of the facility to a contiguous place where the danger was still present, the same danger that was on the premises, and that was known to the individuals who then arguably facilitated the danger resulting in injuries. So there's like a strand that goes out of the premises, a continuing obligation to contiguous property. So if we're going to write narrowly, wouldn't this be a case to write narrowly and say on these facts, a relationship existed, he was escorted by, contiguous place of danger, continuing danger, and facilitated? Wouldn't this be a case to expand the concept rather than constrain it?
Well, I believe with the policy considerations and the negative impacts it would have on bars and restaurants requiring them to
Well,
protect-
wouldn't it address the policy concerns you have? It's not a blanket circumstance in which you're going to extend the potential liability of a restaurant if you simply do eject someone who's misbehaved. I think what Justice Meade is talking about in this circumstance, at least there was evidence that the jury heard that suggested that in addition to simply ejecting the person into separate premises, there was a circumstance in which a bouncer who was present and actually pushed Mr. Booth into a gate. And apparently, as Mr. Booth was about to give his attention to that bouncer, allowed the assailant in this instance to come up and punch him and break his jaw. So what I'm suggesting is those broader policy concerns you're talking about, in most circumstances, would not be an issue. In this context, you have individuals who are employed by the establishment going out and helping to facilitate the assault on Mr. Booth.
Well, we believe that we should cut the liability at the ejection. And Attorney Douglas has pointed this out in his brief as well, that there was no reason for Mr. Akarachi or Mr. Coughlin or Mr. Scott to continue the fight outside.
Wasn't there evidence that was put before the jury that suggested that at least Mr. Reynolds had a suspicion that there might be an attempt to go out and facilitate or to continue the altercation that had taken place on the patio? And Mr. Coughlin, I believe, perhaps presented some evidence that he was concerned about this altercation continuing outside in the parking lot. So the jury heard that evidence, did they not?
The jury did hear that evidence.
So doesn't that alleviate some of your concerns about the broader policy issues of making an establishment, a restaurant, responsible for somebody who they just send out the door without having any concerns or thoughts about there being some further extension of the altercation or the physicality that had taken place inside the establishment?
I guess my concern with extending that is, where does the duty end? Is it a zone of safety?
Well, certainly not before they've facilitated an assault on on the patron that was ejected.
I mean, that's really the problem, is that here, the restaurant folks didn't stop at the door. That's the problem. They went outside with Mr. Booth onto the premises.
So really, just to follow up on all of that, I'm seeing the issue as really one of vicarious liability, not so much territorial. And there's no question that these Amigos employees were acting within the scope of their employment throughout, is there?
I believe that the record does not support that finding. I don't believe anything in the record, that there's anything in there that a jury could reasonably conclude that these men were within the scope of their employment. And that requires a completely different analysis, one that was not brought up at trial, was not argued. So I do believe this should be an issue of vicarious liability. And that would be the correct tool to pursue this under, but not by virtue of this special relationship.
So then what you're saying is, because that's not how they were instructed, we should vacate but remand for a new trial to say it's really just plain old negligence and instruct on vicarious liability.
That's
For
not
the restaurant
necessarily
being responsible for the actions of the bouncers who went outside and facilitated this assault.
It's not necessarily the course that we would like, but I think that would be agreeable, yeah. I just think vicarious liability is the right tool for the job. To try to do this under premises liability is like somewhat akin to trying to hammer in screws, right? Will it get the job done? Maybe, but are the results potentially disastrous? Yes, definitely. Like, I'm not setting foot in a building that's been prepared that way. So if we were going to say that, yes, they're liable by virtue of the special relationship, it comes with all of these other considerations for bars and restaurants. And some of the unclear aspects that
Are there any other cases, though, where the employees of the bar, when we start talking about off-premises and special relationship, are there other cases where the employees went out and were there off-premises when the tort occurred?
There are none in Maine that I'm aware of, and I did not cite to any out-of-state cases that I found where that particular fact pattern had played out.
But isn't that an important factor here? In other words, that it's not just, oh, the person was at risk and we let them leave and a mile away they got in trouble. It's that the employees actually went out with him.
Correct, but I think that needs to be determined through the issue of vicarious liability and whether they were in the scope of their duty when they went outside. To tie Amigos, to hold Amigos liable, that showing needs to be made.
Why? Why can't it be an extension of premises liability?
Well, because if we extend premises liability, it's very unclear as to what are the time and spatial restraints here. How
They are
long are
with
we
this
going?
case. You take each case as it comes, and in this case, on these facts, why couldn't the court simply say that on these facts, this is an extension of the restaurant owner's responsibility?
We could write narrowly and not expand anything to say ordinarily the rule is if you leave the premises, the special relationship stops. But here, because of the danger started inside, he was escorted out by agents of the owner to a contiguous location where they facilitated the assault. Write that really doesn't expand anything. That's a pretty narrow holding if we took that route. Is that a problem from your perspective?
I think it sends a message, or it kind of continues this unclear nature of, what are these bar owners supposed to do? When does this liability end? Like, had, this altercation taken place down the street, would we still be trying to hold Amigos liable under the special relationship?
But we don't have to go that far here. To the extent that you have two individuals, one of whom is an on-duty bouncer and one of whom is an off-duty bouncer, both of whom presented evidence to the jury suggesting that they were aware of the fact there's a possibility that one of the participants inside the patio altercation was going outside for the purposes of tracking down the other participant in the altercation on the patio, that they didn't do anything, notwithstanding the fact that they anticipated that happening.
You may answer.
Well, I believe they didn't have a duty to do anything at that point, unless we extend that special relationship. But again, I don't think that's the correct way to go about this. And it leaves open another case like this. It leaves open the possibility that something similar could happen or occur farther away. And it also leaves bar owners and restaurant owners wondering, am I supposed to walk this patron home or to their car? Do I need to, make sure this person gets to another bar and then it's their problem if this person comes and attacks them there? We don't have any clarity as to that situation. And that's what we're looking for today, is that clarity that we end the special relationship. And in this case, if we are to impose liability on Amigos, we do it through vicarious liability.
Thank you, counsel.
Thank you.
May I proceed, Your Honor?
You may.
May it please the court, my name is Thomas Douglas, and I represent the plaintiff and the appellee in this case, Ryan Booth. In my previous appearances before this court, I've rarely had the occasion to file a red brief. So I'm going to take this opportunity to say something that I rarely get to say. The trial court got it right. The trial court got it right in this case. The court correctly applied Maine law to the facts of this case and denied the defendant's motion for directed verdict. And I would respectfully ask that you uphold that decision. This is a negligence case. If you look at the complaint in this matter, count 1 is negligence, count 2 is negligent infliction of emotional distress. There is no reason for this court to consider amending Maine law, abrogating Maine law, in accordance with foreign authority in order to sort of make heads nor tails out of this case. I think we all understand in this courtroom that under Maine law, a proprietor of an inn or a tavern like Amigos has a heightened duty of care to its patrons like Mr. Booth, and is liable for an assault upon Mr. Booth where he has reason to anticipate such assault and fails to exercise reasonable care under the circumstances to prevent the assault or interfere with its execution. This court has previously stated that in determining whether or not a tavern like Amigos has liability, the touchstone of liability will be the notice of risk, both general and specific, and the exercise or lack thereof of reasonable care. Now, defendant suggests that we need to sort of rework all of this and bring in case law from Illinois and Ohio to draw a bright line for when a plaintiff like Mr. Booth leaves the premises. However, this court has previously stated in Quinn v. Moore, which is cited in the Brewer versus Roosevelt Lodge decision, and I quote, "The reasonable foreseeability of injury to others from one's acts or from one's failure to act raises a duty in law to proceed in the exercise of reasonable care. It is not necessary that the precise type of injury be foreseen, nor the specific person injured." From our perspective, this is the important part. The orbit of danger may be undefined in terms of time, space, or persons. The orbit of danger may be undefined in terms of time, space, or persons. So from our perspective, this court has already sort of resolved the question of whether or not the plaintiff needs to be on the premises, off premises in a negligence case like this one. It's largely irrelevant. The question is whether or not it is foreseeable. And in this case, as I think the court is aware, we have foreseeability in spades, right? This is a tavern with a regular security staff. They know that assaults are going to happen on their premises. With respect to the specific assault of Mr. Booth, we have an assault on the patio. The bouncers come out, right? There's an off-duty bouncer drinking with the assailant. My client gets kicked off the patio, and he's followed out by the assailant, who's all fired up, in the words of the off-duty bouncer.
I see the green light's on. I was asking, as you know, the restatement puts out a pretty clearly defined limitation saying the special relationship does not apply to one who has ceased to be an invitee. If we go the path you're suggesting to us, are we going to blow the lid off that stuff, that rule? Should we just say that rule, the restatement's just wrong, we're not going to follow it, and carve our own niche out of that scenario?
Well, with all respect, Your Honor, that sounds like a premises liability analysis,
Yes.
right? I am sort of advancing a negligence analysis, whereby if it's foreseeable, they're liable. And there are other cases in my brief that sort of advance that position, so I don't think you'd be blowing up anything.
So we don't even have to worry about premises liability here?
That's my position.
Okay.
But how was the jury instructed in this case? I mean, it seemed like everybody got a little bit tangled up in the idea of premises liability.
Right. I don't have the jury instructions in front of me, Your Honor. However, my firm recollection is there was no premises liability instruction. There was a negligence instruction that I believe Attorney Rodway and I went a little round and round about, but there was a standard negligence instruction. To follow up on something that came up with Attorney Rodway, I believe, and again, I don't have them in front of me, but I believe there was also a vicarious liability instruction. You know, basically that Amigos would be liable for the actions of its employees. So we have foreseeability in spades here.
What is the foreseeability? Should Amigos have been able to foresee that a patron who is ejected, because the injury didn't occur on premises, but should Amigos have been able to foresee that its off-duty employee and one of its other employees would have been involved in this altercation?
In this case, Your Honor, absolutely, absolutely. In the first place, there was hardly any training provided to these bouncers. In the second place, one of the bouncers, I believe it was Mr. Reynolds, testified that Amigos had previously had a problem with a bouncer who liked to escalate things inside the bar. You know, he'd like to escalate fights and so on and so forth. There were no instructions provided to these bouncers that I'm aware of.
Was that in evidence at the trial? Was that in
The
evidence?
statement about the previous bouncer?
Yes.
Yes, it was, Your Honor. Yes, it was. That came out in my cross of Mr. Reynolds, or my direct of Mr. Reynolds. So they had notice that they had assaults on the premises. That's why they had security staff. They had noticed that they had previously had issues with at least one bouncer escalating fights, right? And then with respect to the bouncers that were on premises that night, let's look at Mr. Reynolds, right? Mr. Reynolds, I would respectfully submit that he was one of the more credible witnesses at this trial. I'm sure the court is aware of the sort of factual morass that this trial was. No witness agreed with any other witness. But Mr. Reynolds was one of the more credible witnesses at trial. And he said he ejected Mr. Booth, came back in, he encountered the assailant and the off-duty bouncer when he came back in from the patio, and he had a brief conversation with them. He goes back inside, and as he goes back inside, he hears the patio door close. He heard it close, and he assumed, he said at trial, he did not see it, but he assumed that they went out after my client. So I think that's really all the foreseeability you need.
Is this would it be a different case if, let's say, both Jason Scott and Rick Coughlin, I don't know, it kept getting spelled differently, but
Sure.
Had stayed inside and never gone outside after they kicked out Mr. Booth? If they had stayed inside and then Mr. Akarache, I don't know how it's pronounced, had gone out and assaulted Mr. Booth.
I think that-
But that the bouncers had stayed inside, not witnessed it, not facilitated it in any, would that be a different situation?
I think that's a tougher case, Your Honor. I do, because, I think it would depend on, what other alternate facts there were, But I would also say that, if there's a fight on the patio, which there was, right, and then, immediately after, Mr. Akarace storms out the patio door, all fired up, as the off-duty bouncer said. Maybe there's a duty there to at least, that you got to know that this thing is going to continue.
I'm just looking at the special verdict form for the first time here. Question one was the defendant Amigos Mexican restaurant negligent? Yes. Were the proximate cause of the injuries? Yes. Was Ryan Booth negligent? Yes. Did it exceed that? This is a standard four-corner generic negligence verdict that was issued here, assuming the judge instructed on general negligence, which I assume they did. Why are we talking about premises liability?
Beats me, Your Honor.
Okay.
I'm not here talking about premises liability. I'm talking about negligence. Again,
Okay.
it was pled as a negligence case.
Gotcha, okay.
It was argued to the jury as a negligence case. As far as I'm concerned, it's negligence. So,
And
Well,
you're
the
just
jury
going
did-
back to the language in Brewer that basically says they're liable because they have a reason to anticipate the assault, failed to exercise reasonable care to prevent it or interfere with it.
correct.
That simple.
That's the law.
Okay.
I see no reason to depart from that in this particular case. This, especially as the court has pointed out, this assault was eminently foreseeable. You know, you don't need to go out on a limb here to determine whether or not it's foreseeable, whether or not there should be a duty. It was eminently foreseeable, and I think the trial court got it right.
Well, there were certainly a lot of disputed facts, but apparently you prevailed on those facts.
It was a very interesting trial, Your Honor.
The negligence instruction was sort of framed up, though, as a premises, or at least as a special relationship. It says, I'm reading a portion of the instruction which says, under Maine law, a restaurant or similar establishment is liable for an injury upon a guest or patron by another guest or patron, et cetera. So it was sort of framed that way, wasn't it?
Yes, Your Honor. So I want to insert in here somewhere that it was a pleasure to try this case with Mr. Rodway. This negligence instruction, we went round and round on, I think, a couple of times. I wanted this language from, Brewer, from Cashelli, and I think ultimately the court agreed with me. That's where that language comes from. But there was never any talk of like a premises liability instruction or going down that road. It was more to sort of bring it into line with the case law.
And you would refer to, I just want to make sure, you were talking about the off-duty, Coughlin, I think you were saying, was referring to the assailant as being all amped up after the altercation on the patio?
I believe that's correct, Your Honor. And so Mr. Coughlin testified that he was inside getting a pitcher of beer, and he saw Mr. Ackeret, storm off the patio, and he said he was all fired up. I believe that's correct.
And do I remember correctly from the record, though, that Mr. Reynolds, who ejected Mr. Booth, also talked about how amped up Mr. Akarachi was after the episode?
I don't recall that, Your Honor. Mr. Reynolds said he kicked Mr. Booth out, he came back in, had a brief conversation with Mr. Coughlin and Mr. Ackeret. I don't remember if he said he was all fired up. I think what he said was there was some mumbling going on about he was a little so-and-so.
Audibly upset and I think amped up, in that based on that conversation that Reynolds had with the two individuals.
Okay, well, I'm not, if you saw that, and, I'd have to go back and look through my thing, but that's not what I recall. Yeah.
There don't appear to be additional questions. Thank you.
Thank you, Your Honor.
And Attorney Rodway, did you reserve some time for rebuttal?
I did. I reserved a minute. So I just wanted to respond to the idea that this was kind of framed as a premises liability case, and I think that's where the issue lies, is that the duty, framing the actual duty to Mr. Booth, was done through premises liability principles and the special relationship. Certainly foreseeability is a major part of this, but yet, of course, it's foreseeable that there might be a fight at a bar anywhere in the Old Port. To kind of just base the duty entirely on foreseeability, that could open up liability to every bar in the Old Port just by virtue of being a bar in the Old Port. Of course, there is a potential for fights like that, but to impose duty based on the special relationship and allow that duty to continue past the premises is problematic. It exposes all these bars.
You can finish your sentence.
Great. All these bars to this potentially limitless liability, and I believe that it kind of works against the purpose of imposing a special relationship, as the bar doesn't have control over these areas and is really in no better position to protect a plaintiff or a patron from harm in those areas.
Thank you.
Thank you.
As is our usual practice, we are going to take the matter under advisement and issue a written decision in due course. At Attorney Rodway, I understand this is your first appearance, Attorney Rodway Jr., I understand this is your first appearance in front of this court, and our custom is to invite counsel back to take the greetings of the court.
All right.
And you may be seated. And the matter before the court is Workers' Comp Board docket number 24-163, Catherine Stovall versus New England Telephone Company. We are being streamed both by audio and video on the web. And if counsel would identify yourselves by saying your name for the record, together with the party you represent, starting with the appellant, please.
Yes, thank you. Travis Ratcliffe on behalf of New England Telephone Company and
Okay.
the appellant.
It's customary to stand when we
Oh, I'm
talk.
sorry.
Thank you.
Zachary Smith, representing the appellee, Catherine Stovall.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, Chief Justice Stanfill and members of the court. I appreciate the opportunity to be heard today on behalf of New England Telephone Company. Just fair warning, I may slip up and use the term Verizon. It's currently Verizon. At the time of the injuries, it was a New England Telephone Company.
We had a little mini debate on what we're supposed to do about that.
I got that from the clerk, yes. So in a sense, they're one and the same. Just depends on the time frame. Dates of injury, it was New England Telephone. Now it's Verizon. We believe this case involves very important issues surrounding what we view as the overly strict application of res judicata to workers' compensation matters, an overly liberal application of the Pottle and Klimas language from the court about statute of limitations, tolling the statute of limitations, and payments made on one date of injury that, when made with contemporaneous knowledge or notice that they relate or are necessitated by another injury, toll the statute of limitations on that other injury. I think it's impossible to analyze those issues without stressing the long and somewhat convoluted procedural history of this case, which I think is important to both of these issues. Yes, we are dealing with two different dates of injury, 96 and 2001, 5 years apart. However, the description of injury is identical. Both injuries deal with bilateral upper extremities. There is no distinction other than the date of injury between these two claims. Ms. Stovall was receiving benefits voluntarily on an accepted memorandum of payment at the time she filed petitions in 2005 on the 96 and 2001 claims. That eventually made its way to hearing. On the record before the hearing, there was a discussion held. It was recorded, luckily for our benefit. And the parties discussed with the contract ALJ at that time that the employee wished to dismiss her petition on the 1996 claim and proceed on the 2001 claim only. As part of that discussion, you will see in our brief in the appendix in the record on appeal that the contract ALJ specifically discussed with the parties that despite the dismissal of the petition on the 1996, because the employee was continuing to receive benefits on the 96 at the time of that hearing, that the judge's decision in that case would also address the employee's entitlement to receive benefits on the 1996 injury. Counsel for Ms. Stovall agreed to that on the record prior to that hearing. In that setting, the administrative law judge issued a decree in 2006 that said, New England Telephone / Verizon, the incapacity is related to the 2001 claim. You are to pay benefits on the 2001 claim only. Verizon did just that. Our contention is that, considering the discussion on the record prior to the hearing and the decision by the judge that ordered us only to pay on the 2001 claim, that, as a matter of law, affected the discontinuance of the benefits on the 1996 claim. For one thing, an employee can't receive total benefits on two claims at once. The law court has addressed that issue before, so we could not possibly pay total benefits on a 2001
Counsel,
claim.
I see that the green light is on. Do the two issues essentially rise and fall together? It seems like if it's not res judicata because they weren't actually litigated, then one wouldn't be on notice that it was payment on account of that injury.
I think it's critical whether you find that the 2006 decree also served to discontinue benefits on
Right.
the 1996 date of injury.
So let me ask you this on the res judicata. I know that the language that we've used in general for res judicata is broad about what actually was litigated or what could have been litigated. But isn't that all going back to whether it's the same cause of action? And let me just try some hypotheticals. If somebody is in 2 motor vehicle accidents, right, and you sue the driver of the second motor vehicle accident, does that bar a claim against the driver of the first motor vehicle accident?
I don't believe so, because one of the prongs
Because they're
is
2
it has-
different causes of action. They're 2 different claims.
I think one of the prongs of res judicata and claim preclusion says it has to be the same parties involved, correct?
Okay,
So
but it
if
also has to be the same cause. What if the
Correct.
same driver hits you in
Yeah.
year 1 and then hits you again 2 years later? And you sue them about the 2 year later, and all you present to the jury is the 2 year later.
Yeah, I would say move away from that driver, number one.
Well, that would be a good advice.
Number two, so I think.
But aren't those 2 different causes of action, is my point.
Yeah, so I think you hit the nail on the head of where our consternation comes with the res judicata piece of things. It's obvious that res judicata does apply in certain situations in workers' comp. The easiest example is an employee is awarded partial incapacity by decree. They're not locked into partial incapacity for the rest of their life. Either party can show a change of circumstances to either raise or lower that obligation to pay benefits. And just by showing a change in circumstances, you can get an out-of-work note from a doctor, or the employer could get a labor market survey and say there's work available and you're entitled to less partial. So certainly res judicata does apply. In the cases that the appellate division and my esteemed colleague here cite, really I think get to the heart of what you're saying. All of these cases are a same injury, different issues. Spencer was
What
an
if they've
agreement.
been 2 different insurers, for example? That happens a lot, right, where the insurer on the risk changes?
It does, but I think unless it's the same parties in both rounds of litigation, I can't claim res judicata because Ms. Stovall litigated against a previous.
But doesn't that
employer.
actually highlight the fact that there could be different parties, that it's really not the same claim?
There could be, but that's not the case before us. And it's even worse because it's all the same injury. It's 2 different injuries, but it's not 2 different body parts. It's all the same claim.
I understand.
Her incapacity was related to one thing, her bilateral upper extremities. It wasn't a case where my bilateral upper extremities incapacitated me for 520 weeks, but now I have a
But the
back claim.
petition regarding the 1996 injury was in fact dismissed at the time of the decree in whatever year it was, 2005?
Correct, at the employee's request. And I'll just note for you that that's an issue that comes up frequently in our practice. We are entitled to object to that, and we typically do. Our firm didn't represent the defendant at the time that happened. However, that's completely out of our hands, and the judges frequently do dismiss the employee's petitions over our objection, saying we don't have standing to have them continue on that petition. So we have no power to make them continue.
The 2 decisions that the appellate division relied upon for the proposition that only issues actually litigated or barred involved agreements. They both involved agreements to pay. So what was litigated in either of those cases?
Well, so agreements, whether it's a record of mediation or a consent agreement, or in these cases, it was sort of pre-1990, so it was called something else. The case law does say that those are entitled to the same res judicata effective decree or actual decision of the board is entitled to. And those cases sort of highlight our distinction here. You know, Spencer's was a guy, the agreement was on 3 fingers, later a thumb came up. So obviously the thumb wasn't part of the first round. Wacombe, I think there was an agreement on the feet, and then a back injury came up later. So they were litigating a completely different thing the second time around the back. There's no completely different thing in this.
So that's what I hear you agreeing, that the issue about what could have been litigated
Yeah.
was or should have been or could have been litigated really relates to whether they're separate claims or not.
Correct. And our stance is that this is the same claim.
And is that always true when there's 2 different dates of injury then?
Not always, it depends. You know,
I mean, isn't that the problem, is it's 2 different dates of injury?
Well, I think that's it's sort of getting around the should have been or could have been litigated prong of res judicata. I think we're taking the easy way out and saying we're not going to analyze that. Look, if it's a case where an employee has a back strain and they get PT and they litigate it and we pay for the back strain, they have a second injury and all of a sudden they need surgery, I'm going to tell you that those are probably 2 different claims. 2 different injuries, 2 different claims. Ms. Stovall's claim in this case was exactly the same regardless of the date of injury.
But isn't it a nice bright line to use, date of injury?
I suppose,
Just like 2 different car accidents?
I would put it another way. I would say it's the easy way out without actually analyzing whether or not something was actually litigated or should have been litigated under the court's normal res judicata jurisprudence.
Can I ask you about the statute of limitations issue in the time you have left?
Yes, please.
The decision says New England Telephone created a compensation scheme and it filed a memorandum of payment for the 1996 injury. To date, New England Telephone has not filed a petition that would meet the requirements nor contest it. As such, it's required to pay benefits at the rate established, et cetera, et cetera. That's what it says. And I'm looking back at the colloquy at the 2006 conference, and the ALJ points out there's no petition for review here, but are you thinking that the award covers that? The award would take care of any filing for a review? And employer says yes, yes. Employees counsel doesn't seem to quite get what's going on there. And the ALJ says if they had agreed to an award and filed a memorandum of payment, they would have to file a petition for review to knock it down that she's currently receiving. But because they didn't do that, once the award has been established, I can find, I believe, the award you're entitled to so much benefits. So I found it, and it goes down there. So employees counsel says, so you're saying the decision trumps, they wouldn't need to file a memorandum of payment and notice of controversy. He says yes. The lawyer says yes. What's the consequence of that? There's a little uncertainty kicking around there, but what's the consequence of what they said?
You know, and Kayla, my associate and I were talking about this. I wish it would have been discussed a little more succinctly, but the way that we read it, and maybe you don't, and I'm sure Zach doesn't, is the judge is saying that my decision on this 2001 petition could deal with your ongoing receipt of benefits on the 1996 claim without the need for this employer to file a petition for review, which they would have to do in a vacuum.
If you all agreed, does that take the employer off the hook for filing a petition for review to cut off the 96?
I think the issue of which injury was responsible for her incapacity at that time was in front of that contract ALJ, and he found that the incapacity was solely related to the 2001 date.
So you find that there is a statute of limitations defense if we accept that premise?
That's correct.
Okay.
Yes.
All right.
Yeah. So yeah, and statute of limitations, I'm glad you touched on that. Again, this contemporaneous knowledge thing, I can't think of a clearer pronouncement to my client that the payments they were making had nothing to do with the 1996 injury than a decree saying, hey, you owe her, but only on this date of injury. And it's interesting to me how the res judicata and the statute of limitations issues here interlock, because employee counsel will want you to say, for res judicata purposes, that 1996 had nothing to do with that litigation in 2006. Forget about it. But then with respect to the statute of limitations, they're like, hey, how could you not know that these payments relate to the 96? The 96 fingerprints were all over that litigation.
So fair to say that if your position would be that if it's not res judicata, then you also can't say it was litigated in such a fashion as to have given notice and therefore didn't toll the statute of limitations.
I mean, Kayla put it best. It's the cake and eat it too argument. They want it both ways. And maybe you could say we're arguing the same thing, but in this case, so on the remand thing, if there are no other questions on that, just really quick, it's just based on the procedural posture. Look, the claim at the hearing officer or ALJ level was denied.
I think we understand that, and your time is up, actually.
Thank you.
Thank you. Counsel?
If it may please the court. It's a little unclear to me why the court granted the appeal in this case. There didn't seem to be any errors of law.
If you would go over to the podium, that would be helpful. That's where the recording and the all is.
It's a little unclear to me why the court granted an appeal in this case. I didn't see any errors of law in the appellate division's decisions, but here we are. So I want to make explicit, just in case it's not explicit from my briefs, the employer is seeking to impose res judicata principles on an injury claim that was never litigated, anything like a final judgment. In addition, there's no case law, and I have relied on over 1,000 decisions of the law court in the appellate division and the former appellate division in my research on workers' comp law to support what they're arguing for here. If there was some, I would be trying to distinguish that case, but I've never found a case to support their position. I also want to quote a decision from the court, this court, that I neglected to include in my reply brief. The operative subsection of Section 205 requires the employer to petition the board for permission to reduce or terminate compensation. And, quote, crystal clear statutory language. That's Grant v. Central Maine Power Company, 2003 ME 96, paragraph 9. I also want to make clear that equity doctrines do not apply in workers' compensation law, at least in Maine, to the extent that the employer is suggesting this is an unfair windfall to my client or something of that nature, and that the court should exercise, because it's not fair to the employer. It just doesn't matter. There's simply no black letter law and no case law to support that idea. As a sort of addendum to my brief, I stated the employer seems to be seeking an ex post facto adjustment to its compensation obligations. I think the better description would be a nunc-pro-tunc order. The employer's objection to my motion to strike characterized the issue of its admitted failure to discuss the standards of review in its briefs as a minor technical issue. I would say at this point I disagree with that. I believe it's an actual substantive matter of appellate jurisprudence and is very important, and would reiterate that my position is that because the employer's briefs didn't mention or argue for any standard of review, that the more stringent standard of review should apply, as I've argued in my briefs.
You still have time.
I still have time,
Are you
okay.
ceding, or you stopped?
Sorry, I'm a little, it wasn't clear to me the color hadn't changed. The other thing is, the whole thing about the discussion of counsel off the record is irrelevant.
Well, now the green is on. Counsel, can I ask you this? It's sort of the reverse of what I said to opposing counsel, but aren't the res judicata and the notice for purposes of statute of limitations, don't those issues have to be intertwined? In other words, that if a claim is not barred by res judicata because it wasn't actually litigated, then how could it possibly, the same decision, provide notice that benefits paid under the 2001 injury were actually, for at least in part, benefits or necessitated by the 1996 injury? I mean, it seems to me they rise and fall together. Either it was litigated or it wasn't.
That wasn't litigated, but the memorandum of payment, that began the tolling. Is that what the court's wondering? It's not a matter of having your cake and eating it too. The employer.
Sure seems like that.
It's not. The employer simply did not follow the clear statutory language of Section 205, allowing it to it could have done that at any time for many years.
Assuming that, but you still end up with the statute of limitations issue, and so to get out of the because the petition that the employee filed wasn't until after the 10 years had gone by, right?
It was told the whole time.
Well, that's the question.
Let me ask you the same question then. That colloquy that we have here that's a little messy, but basically the ALJ says, the employee says, so you're saying your decision trumps, they won't need to file a memorandum of payment or notice of controversy, that's right, and no petition for review would be necessary. And ALJ says, is that your understanding? And counsel says, yes, that's my understanding. And they basically, they essentially appear to indicate that, yep, this 2006 decree cuts everything off, no petition for review needed to be filed later on, and therefore the time for, there is no tolling that would take place in the meantime. I think you were about to start talking about the colloquy, and I'd be interested in your thoughts on what that does or doesn't accomplish.
My position is it doesn't accomplish anything. If it wasn't reflected in the decree, and the employer wanted that reflected in the decree, what we do in workers' comp practice is after the initial decision comes out, we file a Section 318 motion for further findings of fact and conclusions of law. Any issues that were not addressed in the initial decree can then get addressed by the ALJ, or at the time I think it was actually hearing officer was the title. barring that, it doesn't get reflected in anything equivalent to a judgment.
But there appears to be an acquiescence by employee counsel in that procedure.
There was no acquiescence. My client disputes that and says it was taken out of context. Unfortunately, I don't have the full record with me.
But the petition for award would pull the plug on that for the 96. Then this new award comes out for the later injury, and they had this conversation, which is basically, no, this takes care of, this wipes the slate clean, don't need to file anything further. Can an agreement of the parties override a statutory duty?
No, there would have to be some kind of written release. There's nothing in the statute that allows that. They have to petition. It's very clear. And it may not seem fair, and
you're about to say that equity doesn't control these proceedings.
Yes.
The fact that the employee may have sat on this for a number of years or discovered it at the last minute isn't part of the analysis.
Right, and I can say that things work in the other direction where employers or insurance companies enjoy what would seem to be windfalls through the strict application of the statute. In other situations, I've had two clients, two injured employees. We had positive medical opinions that they had work-related injuries and were incapacitated by them. They did not provide timely notice. The notice period has ranged between 30 and 90 days over the years. And it was a total defense, and so that would be a windfall, and I'm sure these aren't the only people that's happened to.
The 2006 decree did not wipe the slate clean, and that the rights that occurred under the previous memorandum of payment were still continuing to tick away.
It's the employer's or TPA's or insurance company's duty to adjust its claims and handle its claims. It was not her duty to say, hey, you haven't cut this off yet. And they didn't, and at some point my client realized it.
The appellate division noted that in the 2006 decision, the board, I'm quoting, this is from appendix page 146, an appellate division decision. I quote, the board, Smith, contract hearing officer, found that Ms. Stovall experienced a work-related injury on June 29, 2001, and that the injury was a significant aggravation of the earlier 1996 work injury to the same body parts, end of quote. That's a finding of fact. Doesn't that mean that the payments on the 2001 injury were related to the 1996 injury? And does it follow from that the 2011 decision on the employer's petition for review adjudicated both injuries? Is that an implausible analysis?
I don't think the 2011 decision would have adjudicated an injury that was not brought before the board. There are situations like this one where the distinction between a new injury and an aggravation of an old injury, and there's research on this. Larson's treatise talks about it. But sometimes it's unclear.
Following up on a point that Chief Justice has made, if the 2001 injury was an aggravation of the earlier injury, doesn't that mean that the petition for restoration could have been filed in 2011?
Perhaps, but it wasn't.
Should have been?
I would not say that. I mean, I don't think there's any argument that my client was.
That gets into whether we adopt the actually litigated and leave it at that, or that might have been litigated as well, right?
The statute doesn't, my client followed the statutory requirements that if the legislature wanted to impose certain time limits, it knows how to do that and has done it throughout that statute. The employer's argument here is to basically engraft an entirely new scheme in the name of res judicata that is just not in the statute. And I think this court would be overstepping its bounds to add something through the case law that's really not consistent with the statute.
Let me ask while there are no other questions. There's a provision of the statute that no party has mentioned or briefed, and therefore I'm a little hesitant to ask about it, but subsection 9A of section 205 reads, quote, "If the employee has returned to work with or has received an increase in pay from an employer that is paying compensation under this act, that employer or that employer's insurer or group and self-insurer may discontinue or reduce payments to the employee," end of quote. And Ms. Stovall, there's no question that she received a pay increase between 1996 and 2001, which is why she elected for the 2001 benefits. And she and New England Telephone / Verizon was still paying compensation under the act. Does that suggest that the employer was entitled to discontinue payments without petitioning to do so?
No, that applies only if it's a return to work with the same employer. And
Wasn't it the same employer in 2001 and 1996?
Well, if I understand the court's question, it's asking whether they could have been an offset or termination based on her return to work for a different employer, not for New England Telephone or Verizon.
Well, it seems to say if she returns to work with or has received an increase in pay from an employer paying compensation under this act, that employer, i.e. New England Telephone, or that employer's insurance or group insurance may discontinue or reduce payments.
I don't think that applies here.
Okay.
That's not what it means, apparently.
Apparently, but it seems like that's what it says. That's the danger of non-comp judges dabbling, huh?
Speak for yourself.
So, yeah, I don't think that applies. That has always been for the same employer when someone gets a new job or gets a raise with the same employer while receiving compensation. That's why it's allowed, as a way to, you don't have to petition as an employer for permission from the board, but in all other situations, when there's a decree, memorandum of payment, settlement, you have to petition the board and get permission.
But only if it doesn't fall under subsection A of subsection 9.
Right, and then this situation did not fall under that paragraph.
There don't appear to be additional questions, and I think it's about to turn blue anyway. There you go.
So, if the court has any further questions, I'm available to brief. I have extensive research on the case law and the statutory history of Title 39A and Title 39, but otherwise, I see the rest of my time.
Thank you. And counsel, you wish to be heard in rebuttal.
Yes, thank you. Briefly, on the issue of contemporaneous notice or knowledge on the statute of limitations issue, our position on this is that the appellate division is looking at this through the wrong lens. It's essentially saying that as long as an employer knows that there are two injuries, whether or not the other injury necessitated in part the payments, it's just enough that the employer knows that those two injuries are there. When they make a payment on this one, it applies to that one. I don't think that's what Pottle and Klima say. I think they both specifically use the word the payments were necessitated by the prior injury. And remember, the decree in this case said that her incapacity was related only to the 2001 claim, and you're only to pay on that 2001 claim, not the 1996. And on the issue of res judicata, we're not trying to create something new here. Our argument is it was actually litigated at that time based on the discussion prior to the record and the ultimate decision that said that you pay only on the 2001 injury, and that the decree itself was de facto by law a discontinuance on that 1996 claim. The appellate division's reliance and opposing counsel's reliance on the
What's the
2005...
meaning of the section that Justice Horton raised?
2059A?
Yeah.
So that only applies when an employee returns to work for the same employer at which they were injured, and we're allowed to reduce or discontinue benefits based on their actual earnings with that employer.
But didn't she return to work for the same employer?
Not at the time she filed her petition for restoration on the 1996 date of injury. She was not working for Verizon. She
Okay.
didn't return to work until later, until just before the appellate division's decision, or sometime before the appellate division decision, when she returned
Well,
to
my
work.
question was related to whether she was working for the same employer in 2006 when, or 2005 when when New England Telephone Verizon started making payments on the 2001 injury.
Boy, that's a good question. I don't know that I know the answer as of 2006. It was my understanding that she wasn't at that time. The decree ordered total for a period of time, and then a 40% partial after that based on her restrictions, availability, or work. And
But at some point, she returned to work and got a higher rate of pay. That's why I think we're...
well, I don't know if maybe we're a little confused about what we said in our brief. So the average weekly wage was higher on the 2001 claim than the 1996 claim.
Right.
So she proceeded under the 2001 claim and got a higher compensation rate based on that higher average weekly
But
wage.
that's what I'm saying, is I think that's where we're getting confused, is it seems
Yeah,
like...
that had nothing to do with the return to work to Verizon. It was just a higher average weekly wage applicable to a 2001 claim as opposed to the 96.
Okay, thank you.
Thank you.
Thank you. All right. Well, as is our usual practice, we are going to take the matter under advisement, issue a written decision in due course. And it is also my understanding that it is your first argument in front of us?
Yes.
And so our practice or our custom is to invite counsel back to take the greetings to the court after the argument. And with that, I believe we're in recess for the day.
All rise. All persons